What's up? Welcome to the courtroom.
I am Theo.
And I'm Oj. And in this podcast, we tell you stories about people's life, liberty, and property.
Ikwentuhan namin kayo about court rulings in a way that will make you understand jurisprudence like a 9-year-old.
All persons before the Honorable Supreme Court of the Philippines shall give their bench, for the court shall be.
So join us as we delve into true crime, political controversies, and all things started and chismis every week. Ang bida kasi sa kwentong ito ay ang magjowang si Francisco Paquing Velez at Beatriz Beth Wassmer. Following their mutual promise of love, they decided to get married on September 4, 1954. Syempre, they started na to prepare for the wedding. They applied for and was issued a marriage license, nagpaprint na ng invitation, at napadala na sa family, friends, at madlang people. The bride-to-be trousseau, bongga, trousseau, or what we call the bridal gown. Also, the party dresses and other apparels were already purchased, including that of the maid of honors and the flower girl. Pati yung matrimonial bed with accessories was already bought. Bridal showers were already given and wedding gifts were already received. Parang social ikasal nung 50s, no? Nauna yung gifts kaysa doon sa kasal.
Actually, oo nga, no? Ba't kaya hindi natin i-adapt yun ngayon?
Oo nga, gano'n na lang.
So, ayun nga. Ang dami na agad ganap. Kaso, 2 days before the wedding, guess what?
Guess what? What?
Nowhere to be found si Francisco. Ang nakita na lang nila is a note for his bride-to-be. And unfortunately, hindi masaya ang content. Eto, basahin natin.
Dear Beth, we'll have to postpone wedding. My mother opposes it. I'm leaving on the conveyor today. Please do not ask too many people about the reason why. That would only create a scandal. Paquing.
So, yun. Nalaman na lang ni Beth, umuwi na sa bahay si Francisco.
Bahay lang pala eh. Sa may bahay.
Sa bahay niya sa Mindanao.
Wow.
And the next
Mindanao
day...
Ave.
Hindi, Mindanao talaga. Sa CDO. And the next day, the day before the wedding, nag-telegram pa sa kanya si Kuya. Sabi sa telegram,
Nothing changed. Rest assured, returning very soon. Apologize. Mama, Papa, love, Paquing.
but the runaway groom never returned and was never heard from again.
Left alone, unmarried still, Beth sued for damages. And because our ghoster groom, Francisco, never filed an answer, Beth won the case with a favorable judgment by default. She then presented her evidence before the clerk of court as commissioner, and on April 1955, a judgment was rendered ordering Francisco to pay Beth 2,000 pesos as actual damage, 25,000 pesos as moral and exemplary damages, and 2,500 as attorney's fees and other costs.
Malaki-laki din pala yung damages sa mga ganyang ghoster groom, no?
Oh, and that is a huge amount even by today's standard, considering happens in the 50s. Pero just when she thought it was all over, less than 2 months after the final judgment, biglang sumulpot si Francisco and filed a petition for relief from order, judgment, and proceeding at motion for new trial and reconsideration. He alleged that it was due to excusable negligence that he was not able to file an answer and asked the court to set aside the judgment by default. Ang excuse ni Francisco is that akala niya daw kasi may amicable settlement that was being negotiated on his behalf.
Siyempre, si Beth opposed both the petition and motion of Francisco. But the court ordered the parties and their attorneys to appear before it. Gusto kasi ng court na explore yung possibility of arriving at an amicable settlement. Baka nga naman kasi maayos pa, di ba? Pero may caveat. The court added that should any of them fail to appear, the petition for relief and the opposition of Francisco will be deemed submitted for resolution. Meaning, ire-resolve na ng court yung issue based dun sa mga submitted documents na inaccept ng court.
So, ano nangyari sa amicable settlement nila Beth at Francisco?
Wala. Kasi, etong si kuya mo, etong si Francisco, hindi umattend. Instead, the next day, nag-file yung attorney niya ng motion to defer for 2 weeks the resolution on Francisco's petition for relief. Sabi ni attorney, usap muna daw sila ni Francisco dun sa residence niya sa Cagayan de Oro. Kasi, baka may possibility ulit for amicable settlement. So, syempre, yung court granted the said motion.
Now, 1 year later, well, almost, on June 15, 1956, nag-manifest si Beth. Sabi niya, expired na yung 2 weeks na grinant ng court nung September 8 pa. And hindi pa din nagpapakita si Francisco at yung counsel niya.
Matibay pala tong si Francisco.
Iba din eh, no?
Yeah, iba din.
So, the court once again gave one last chance for the party to reach a settlement. Di ko lang talaga alam if dakilang pasaway lang talaga tong si Francisco, pero di pa din siya umattend. Iba talaga. And this time, he just had his counsel inform the court na wala nang chance for an amicable settlement between him and Beth.
Ayos after all those chances na hiningi nila sa court, dun din pala yung bagsak. So, on July 20, 1956, nag-issue na ng order yung court denying Francisco's petition for relief from orders, judgment, and proceedings. At saka yung motion for new trial and reconsideration niya.
Wait, why was it denied?
Because a petition for relief from judgment on grounds of fraud, accident, mistake, or excusable negligence must be duly supported by an affidavit of merits stating facts constituting a valid defense. Kaso, sa affidavit of merits ni Francisco na naka-attach sa petition niya, ang nakalagay lang is that he has a good and valid defense against Beth's cause of action, and that his failure to marry her as scheduled is due to a fortuitous event, and yung circumstances are actually beyond his control. Yun sabi niya. Na problem is, hindi niya inelaborate further kung ano yung mga circumstances na yon. Syempre, an affidavit of merits like that is not valid as per the Supreme Court.
Not valid because...
Well, because yung affidavit of merits niya merely stated conclusions or opinions instead of facts. So, nope, no deal.
Pero sabi naman ng kampo ni Francisco, di na dapat pinag-uusapan if may merit man yung facts ng affidavit niya. Di daw mahalaga kung anong reaksyon niya sa di pagsipot sa kasal nila ni Beth, regardless of the reason. The judgment against him should be set aside since wala naman daw provision sa civil code na nagsasabi na ang breach of promise to marry is an actionable wrong. Therefore, contrary daw sa law yung naging judgment against him because technically, wala naman daw siyang nilalabag na batas. Kaya, ang tanong, is it really a crime to break an engagement or call off a wedding?
Courtmates, what do you think? Anong side ba? Kaninong side ba kayo? Team Paquing ba kayo or Team Beth? Let's see kung anong say ng SC. But as per the Supreme Court,
Paquing. Yung ba yung pangalan love team nila?
pwede. Baking. Pwede.
Pakbet.
Pakbet.
Pakbet. Team
Medyo
Pakbet.
healthy pag pakbet. So, as per the Supreme Court, the extent to which acts not contrary to law may be perpetrated with impunity is not limitless. Meaning, hindi porke hindi contrary to law yung act na ginawa mo, automatically, lusot ka na agad. Exempted na agad from punishment. Siyempre, hindi ganon. It must not be overlooked. Kasi, under Article 21 of the Civil Code, it says, any person who willfully causes or loss or injury to another in a manner that is contrary to morals, good customs, or public policy shall compensate the latter for the damage.
Kita naman how this wedding started with dreams, hope, followed by an elaborate planning and a series of endeavors only to be terminated in frustration and complete public humiliation. Surely hindi lang mere breach of promise ang pinaglalaban ni Beth dito. Sabihin man natin totoo, ang breach of promise to marry is not an actionable wrong. But to formally set a wedding and go through all the stressful preparation and publicity, tapos the groom will only walk out when the matrimony is about to be solemnized, aba, ibang usapan yun. That is palpably and unjustifiably contrary to good customs, which is, in accordance to Article 21 of the Civil Code, answerable si Francisco sa damages.
And since walang lusot si Francisco, ni-raise niya na lang yung damages awarded were actually excessive. Although, wala naman siyang question dun sa 2,000 pesos na actual damages, ang issue niya is yung award of moral and exemplary damages na 25,000 pesos. He asserts that it should be totally eliminated. Pero, under Article 2219 of the new Civil Code, moral damages are recoverable in the cases mentioned in Article 21 of the Civil Code. Since pasok nga yung ginawa niyang act under Article 21, proper lang naman na i-award ng court ang moral damages in favor of Beth. As to exemplary damages, sabi ni Francisco, it should be eliminated. Kasi under Article 2232 of the new Civil Code, the condition precedent is that the defendant acted in a wanton, fraudulent, reckless, oppressive, or malevolent manner. Pero, sabi ng Supreme Court, devoid of merit naman yung argument neto ni Francisco. Kasi, tingnan mo naman yung mga circumstances ng kaso. Very clear na si Francisco acted in wanton, reckless, and oppressive manner. Imagine mo, after all the preparations done for the wedding, 2 days before, ikakasal na lang, nag-alsabalutan pa si kuya mo. Tapos, sasabihin niya, hindi daw wanton, reckless, and oppressive yun. Siyempre, the court begs to disagree.
Nagugutom ako sa kawanton mo.
Yun
Word
lang pala,
of the day.
yun lang pala yung pinakinggan mo, no? Yung
Word of the
wanton.
day, wanton.
Hindi ba
It
truso?
means deliberate or sadya. Pwede ring truso, sige. So, back to the case. The court naman is reasonable and modified the amount of the moral and exemplary damages from 25,000 to 15,000. Hindi pwedeng wala. Minodify lang ng court. Since, given the particular circumstances of the case, yung 15,000 naman daw is deemed to be proper and acceptable award already.
In short, bayad pa din si kuya mo.
And si Beth may not have the wedding she had always dreamed of, but at least, she got the justice she deserved.
If you guys like this audiogram, please listen to the full episode on Spotify or on your favorite podcast app, where you can hear our insights on this case. Again, this is Oj.
And Theo, leaving you with a reminder to always look back in history because precedent shall rule the future.
Thank you for listening, and we'll see you again in the courtroom.
Bye!